Life of a Child Welfare Case. The Division of Child Protection and Permanency, DCP&P, formerly DYFS, submits a complaint. A complaint is a legal document submitted to the court by DCP&P that includes the reasons they are making the complaint. It describes their concerns for your welfare and what they would like to be done to protect you. The complaint will also include your name, age, and birthplace. The name and address of your parents or guardians will also be included. Initial hearing. At this hearing, DCP&P must explain to the court why a court order is needed to keep you safe. Your law guardian will be at this hearing to help protect your interests and, if they know your wishes, tell them to the court. If your law guardian is not able to meet with you at the hearing, he or she will contact you afterward to meet. Your parents may also be represented by an attorney. If the reasons provided by DCP&P are not sufficient and the judge feels that their help is not needed, your case will be dismissed. If you were removed from home, you will be returned. If the reasons provided by DCP&P are sufficient, a case is opened and another court date is set. Return on order to show cause. This is the next hearing in your case. The judge will want to see that everyone has an attorney to provide an update on the case. DCP&P must provide reasons as to why they believe they should remain involved and whether there are any new recommendations to help your family. Your parents' attorneys will present their positions. Your law guardian represents your position at this hearing. This is an opportunity for your law guardian to raise any questions or concerns you may have about things such as where you are living, visitation with family members, your education, and anything you may need. The judge may keep the case open and you and your family may receive services. The judge may decide it's now safe for you to return home with or without services. At the end of this hearing, dates will be set for a fact-finding and compliance review hearing. Fact-finding hearing. This hearing is held within 4 months of the beginning of your case. DCP&P must prove that abuse or neglect occurred according to the law. All the participants, including your law guardian, can provide evidence to support their client's positions. If the judge does not make a finding of abuse or neglect, the case may be dismissed. If the judge makes a finding of abuse or neglect, he or she may order additional services and the case continues. Dispositional hearing. This hearing usually happens right after the fact-finding hearing. During this hearing, the judge decides what will happen next in your case. The judge may decide that you will stay with family, will be returned to family, or will live in a foster or group home. The judge may also order services for your parent or guardian. This is temporary until the permanency hearing, and the order can also be changed during periodic review hearings. Periodic review hearings. Also known as compliance review hearings, these hearings happen about every 2 or 3 months during a case. The judge uses these hearings to make sure that services are being provided. The judge wants to make sure your needs are being met and address any questions or concerns you may have about things such as where you're living, visitation with family members, your education, and anything you may need. Permanency hearing. If you have been placed away from your family, this hearing happens within 12 months of your case being open. Under the law, you must be notified and can attend this hearing. There are 4 different outcomes that may result from this hearing. Return home, reunification. If you were removed from your home, DCP&P is ordered to return you to your parent or guardian within a reasonable time frame. Termination of parental rights, TPR. If it is not safe for you to return home, the plan may be changed to adoption. For this to happen, DCP&P must file a complaint, and there will be a hearing for the judge to decide if adoption is the right plan. Kinship Legal Guardianship, KLG. This is when the judge decides you will live permanently with a friend or family member. This might include continued visits with your parents. Alternative living arrangement. This is another option for some cases and may include living more on your own or in a residential facility. Cases can take a long time, but it is important that you are heard in your case. You should talk to your law guardian about any questions or concerns you may have about the court process.